Hello, friends. This is Sundareshan, your compliance guru. Liability of a director, whether it is an executive director or a non executive director or an independent director. So, in the last video, we were on this point, on which I was making a lot of emphasis, which is every director who was aware, that is where we had stopped, who is aware of the contravention and had given consent, such person will fall under the category of officer in default. Very clear? So, such a director will fall under the category of officer in default. Now, before analyzing those provisions, you should also understand where you will be liable and for what you will be liable. Now, law prescribes for penalty in each of the provisions, each of the sections. Should I be worrying about all that? Not to a great extent, because if in most of the cases, the penalty that is prescribed or the fine or whatever the shortcomings of that provision is done is in the form of very clear either fine, penalty, or an imprisonment. And who is liable for any of this? The company and its officers. Now look how the wordings are. And when we saw in one of the previous videos what the definition of an officer was, it also includes a person who had given the consent, which is a director who has given a consent. So, today what we would focus on is the concept of knowledge. Now, why knowledge? Because it's very clear. An independent director or a non-executive director shall be liable only in respect of acts of commission or omission by a company which has occurred with his knowledge, attributable through a board process. Attributable through a board process, and his consent or connivance, or where he has not acted diligently. So, very simple. Knowledge through a board process. First of all, you should know what is knowledge. Knowledge. The dictionary meaning, leave that alone, but for the purpose of a director, you should understand. Knowledge means information. The moment you get any document, it means it's information. You open the document, the knowledge gets converted into understanding. You start reading the document and start apprehending things, it becomes awareness. So, friends, you cannot say that I did not have knowledge, because you would have committed at least one of these three things, which is receipt of document, information, opening the document, understanding, reading the document, awareness. Now, the only way you can say I did not have knowledge is when you have not received that particular document. The onus is on you to prove that you have not received the document. Next, through the board process means what? In a board meeting. So anything that you come to know which is outside of the board meeting, just don't bother. But whatever you need to know should come into the board meeting. Please, what you have no knowledge, the proof is you have not been brought to the notice of certain things in a board meeting. But if the matter is laid in the board meeting, you have knowledge. Next, there is a process of voting. You participate in that, there is either a consent or a dissent. Now, if you think you are intelligent enough to be quiet or smart enough to be quiet, that falls under the category of connivance. So, whichever ways you look at it, if that matter is being discussed in a board meeting and you participate in that, you are part of the process. Last one, acted diligently, which is you did not know something, no issues. The law says please consult some persons who have knowledge in the subject matter and come inside the boardroom. Whereas you cannot walk into the boardroom and say, I did not have knowledge, so I'm not liable, so hence no imprisonment for me. So, when is an independent director or a non executive director not liable? They are not liable when there was an item that was not discussed in a board meeting. That item, the board did not consult or take your consent on that particular matter, and you did not act diligently, or you acted diligently and you saved the situation. So, understand, only under these circumstances can an independent director or a non executive director be not liable, and the onus to prove rests with you. And when I say rests with you, the only evidence to prove all of this is called the board minutes. So, friends, before I conclude, ensure that as a board member, you do not fail or you do not forget to collect a copy of the signed board minutes of every meeting that you had attended. I think if you have that, you are safe, you are compliant. I will see you soon in some time. Goodbye, good luck.